Have you ever scrolled through camp registration forms, perhaps feeling a little overwhelmed by all the legal language, and wondered what exactly some of those sections mean for your child and your family? It is common to pause when you see words like waiver or liability and think, what am I actually agreeing to here? Waiver of liability clauses in camp forms are essentially agreements where you, as the parent or guardian, acknowledge and accept the inherent risks associated with camp activities. In signing this, you generally agree not to hold the camp responsible for injuries or damages that might occur during those activities, especially if they are due to ordinary negligence inherent to the risks of camp. It is a fundamental part of the camp registration process, designed to protect the camp from unforeseen circumstances. The core reason camps include these clauses is to manage risk and to ensure the sustainability of their programs. Camps inherently involve activities like swimming, hiking, sports, and sometimes even archery or horseback riding, which, while fun and enriching, carry some degree of risk. By having parents sign a waiver, camps establish that participants understand these risks and that the camp has taken reasonable precautions, but cannot guarantee zero incidents. This legal protection allows camps to continue offering diverse and exciting experiences without constant fear of litigation for minor accidents. To understand what you are agreeing to, start by reading these clauses carefully. Look for specific language describing the types of activities covered and the risks involved, such as physical injury, illness, or property damage. If a clause seems unclear or overly broad, do not hesitate to contact the camp directly and ask for clarification from a camp administrator. They should be able to explain the specific wording and their protocols for safety and supervision. An important distinction to remember is that these waivers typically cover ordinary negligence, meaning accidents that can happen despite reasonable care. They generally do not protect a camp from gross negligence, reckless conduct, or intentional harm. Many states also have specific laws regarding minor waivers, sometimes differentiating between activities that are essential to the camp experience and those that are optional. For instance, some states might scrutinize waivers for very young children differently than for older teens, acknowledging varying levels of comprehension and risk assessment. Ultimately, understanding waiver of liability clauses empowers you to make informed decisions for your child's camp experience. By carefully reviewing these documents and communicating with the camp about any concerns, you ensure that you are fully aware of the agreed-upon terms, allowing your child to safely enjoy all the wonderful adventures camp has to offer.